Welcome everyone. Good afternoon. Thank you so much for joining us today. We are very excited to be with you, and we are here to discuss the Secure Act 2.0 in a very conversational format. We want to provide you with the general understanding of what our legislators meant to do in passing this huge act and what the practical outcome has and will be for you as plan sponsors and your employees. I am your host, Carmela Elko, Managing Director at Trinity Advisors Group, and I am joined by my esteemed panelists here, Michael McCabe, President at Trinity Advisors Group, and David Hall, Chief Marketing Officer at Hall Benefits Law Group. So welcome, gentlemen.
Thank you.
Thank you.
So just to give you some perspective, there are 92 provisions in the Secure 2.0 Act. So if you found it challenging to keep track of what applies to your plan and when it applies, you're not alone. So when we planned these webinar sessions, we wanted to make it very conversational so we can actually have discussions around the impact and the intent of the Act, and give you some palatable bites as it relates to the vast number of provisions. So we're here to give you general understanding of a few provisions today that we thought were the most impactful, focusing on when they become effective and what you should be thinking about from a planning perspective. We're also conducting this series especially tailored for small businesses and nonprofit organizations. So please feel free to join those. We have the small business session on Thursday, and the nonprofit one is next Thursday. We also have another general session next week where we feel that we can, add to any questions that we have today and focus on some additional provisions of this act. So, again, we're here to generate ideas, have conversations, get you thinking around strategic planning in order to help you get ahead of the curve as it regards to the Secure Act 2.0. So we'll be recording our WebEx series so you may refer back to them if you feel the need or want to share them with colleagues. In addition, you may download some helpful materials during the webinar. We will also be sending them out in PDF format. So please feel free to look at the handouts and feel free to ask questions, which we will answer at the end with time permitting. So without further ado, let's begin. So gentlemen, we want to start at the beginning. What is the Secure 2.0 Act and why is it such a big deal? So Michael and David, can you briefly discuss the idea of intent versus impact for the audience and explain, why we took this direction with our conversation?
Sure, and I think that, Carmela, is probably the most important question for us to be asking ourselves today, because we're not going to dive deep into lots of different provisions. So by way of background, if you don't know me, my name is David Hall. I'm with HBL. We're a boutique ERISA law firm headquartered in Atlanta, Georgia. But we do serve plan sponsor clients in 39 states. And so we, just like you plan sponsors and other service providers who may be on the call today, had been waiting with bated breath for this Secure 2.0 to pass. And then, finally, the act was signed into law on December 29th of 2022. And here we are with this laundry list of things to think about. And so before we, jump in with both feet into the mud, if you will, I do think it's very important for us to consider the intent of Congress. And then as business owners, as service providers, as plan sponsors, to think about what that impact is to our business, to the way we serve our clients. And so that's the nature of this conversation. When I was talking with Carmela and with Michael about what this might look like, we really thought that that would be a better approach than to just regurgitate, if you will, 92 provisions and talk about how they're each going to work and the timing around each one. So the fact is, you can get those a provision by provision breakdown of the Act online if you want. We're probably going to be sending you something along those lines as follow-up, right, that you can use as a reference point. But at the end of the day, what really matters is how the Act impacts plan sponsors. So let's start at the beginning and think about what Congress intended by Secure Act 2.0. Now, the stated intentions of Secure Act 2.0, according to Congress, were fourfold. First of all, Congress wants to expand employee access to retirement plans. Secondly, they want to increase Americans' retirement savings. They want to, thirdly, preserve Americans' income. And then most importantly, perhaps for plan sponsors' perspective, streamline some formerly complicated retirement plan rules for both your participants and you as the plan sponsor. So look, regardless of the intent of the legislation or the intent of the legislation's authors, plan sponsors are left with lots to think about. You've got questions around elective changes versus mandatory changes. You've got questions around effective timing of provisions. When do things become effective? The perception of plan participants, right? I could go on and on. But now that we've taken a step back to think about the stated intent, Michael, maybe you could speak to the three areas of impact that our conversation will be centered on today, and then we can jump into some specific examples to hopefully get the conversation started among our audience.
Absolutely, David, and thank you. And thank you, Carmela, as well. Before I jump into the original impact of Secure Act 2.0, just to give you a little background on our firm, Trinity Advisors. We are retirement plan consultants, so our sole focus is on 401k, 403b defined benefit plans, and helping plan sponsors develop, manage, maintain the optimal plan to meet their goals and provide the best possible benefit for their participants. Getting more in focus on what the actual impact is, like all government regulations, it's never simple, clear, and easy, right? There's many hoops that have to be discovered and jumped through. So what you're feeling, confusion, if you're unsure, you're not alone. Most of the people that we talk with feel the exact same way as you did. And what we're finding is that the deeper we dive into this, the more clarification we're getting and the more we'll be able to share with you. But there's certain things you need to know. And those impacts are what is required versus what is elective. The second thing is timing, as David had mentioned, about when these provisions take effect, anywhere from this year all the way out through 2027. Some of the tax implications that you may encounter as a plan sponsor. So the impact is really vast. David mentioned that we're going to talk about three different provisions of the Act. And the first one we really want to talk about is the Roth provision inside the Secure 2.0 Act. So we know that there's a difference from a participant standpoint from pre-tax to Roth contributions, right? Pre-tax go in before tax. And as participants pull the money out, they have to pay taxes on the full amount, the money they put in plus the growth. With Roth, money goes in after tax. That money grows, but at retirement, a participant does not have to pay taxes on the way out, so they get tax-free growth. With Roth provisions, Section 604 is going to allow employers to put their company match or contribution into the Roth category. So the intent is great, and the intent of doing this was so that the U.S. government could collect tax revenue immediately through the Roth as opposed to deferred revenue inside the traditional 401k. David, you want to share some of the impact this is going to have?
Sure. Well, look, on one level, to your point, Michael, I do think this could be seen as, and it depends on, I guess, where you lie on the political spectrum. But there are those of us who would look at this as a very altruistic act on the part of the U.S. government. There are others who would look at this as a revenue grab, right? Mm-hmm. And so because they will collect those tax dollars sooner, they may not get as many at the end of the day because, as we all know, we don't know. Other than the fact that taxes will more than likely be much higher in the future than they are now, we just don't know, right? So there's the sure thing on the tax dollars collected up front by the government. But let's also remember the stated intent, right? The stated intent is to increase savings and expand access. And so there may be people, and I say people, there may be participants who are more likely to participate, who would prefer a Roth match. And so that provision to, the intent, excuse me, to increase savings and expand access, this provision does seem to do that on a couple of levels. So there is a lot of upside to post-tax contributions, right? The growth on those distributions will not be taxed. The corpus is taxed one time at its beginning before it grows, right? For plan sponsors, there really doesn't seem to be a downside here. You're giving folks an option that they may not have had, and there's really no FICA implications, and giving those participants more than rather than less options with their money typically acts as an attraction tool rather than a detriment to participants. So here, I think the advantage or the impact will be greater for those plan sponsors who figure out sooner than later if they want to take advantage of this optional provision, think critically about why they might like to do so, and then get out ahead of their competitors in the industry, in whatever industry you're in, construction, auto manufacturing, boat building, it doesn't matter, right? But if you have competitors who are going to benefit from a similar change to their plan, then you want to be the first to do this, and you want to lock these people in with those Roth matches.
Thank you, David. I also think that if a company is going to reevaluate or determine if they want to add this provision to their plan, it might be a great time to evaluate your overall employer contribution formula, right? Whether you have a match or a profit sharing contribution, to kind of look at that overall package. And if you're making additional changes like adding this option for employees. So, and I agree, I think it's a great option for differentiating yourself as an organization. So,
Carmela, I think it's also important to recognize that this provision is effective for calendar year 2023.
Thank you. Yes, that's always important when they're effective, the effective date.
And Carmela, I do recognize we're literally halfway through our conversation, right? So this is meant to be bite-sized chunks. Let me just make one more observation. If you make this change and you don't talk to your participants about the benefit, and you make the change in a vacuum, you may as well not make the change, right? There's really there's no benefit to you as an employer to do this or not to do this from a tax perspective. You gotta think about your audience, right? In the same way that we thought about our audience before we put this webinar on, what is it you want your participants to understand about the reason you're making the decision that you've chosen to make? And decisions made in a vacuum really won't have an impact. So that'd be my only final thought on this particular provision.
No, thank you. That's a great point. And as we move into our next discussion point around participant savings, again, I think the important piece to note here is to understand your employee population, right? So we're going to talk about student loans. The student loan provision permits an employer to make a matching contribution with respect to a qualified student loan payment. So Michael, how does this mechanism work, and what should plan sponsors be thinking about when considering this provision?
Kamal, this is a provision that's kind of near and dear to my heart, as I have 3 kids, all who have student loans and are young and just starting their careers. But effective 2024, participants inside a plan who have student debt will now be able to participate in a company match if it's available, if it's offered, for the first time. Unfortunately, we all know a lot of people who have student debt and they can't afford to participate inside a company-sponsored 401k or 403b plan because they're using that money to pay down student loans. Mm-hmm. Because of that, they aren't able to participate or get, if a company offers it, the match. So now what's going to happen is, if a participant student can show that they are in fact paying down student loans, they will qualify for the company match. The intent is great. The intent is to help participants be able to put more money away for their retirement. But there's a lot of things that have to occur before that actually takes place. So we also have to understand that it's totally optional. So this is not required. So this is an optional provision that a plan sponsor, a 401k, a 403b committee will choose to implement inside their plan. What we have to think about is how this will be implemented and what the impacts will be. David?
I couldn't agree more, Michael. You know, on the face of it, this seems like a no-brainer. It's been a hot topic for some time. I remember when several years ago we had plan sponsors and advisors coming to HBL asking, how can I help my plan participants who have student loans? They're not participating in the 401k. We don't have a mechanism by which we can help. You know, this answers that question. On the face of it, it seems like a no-brainer, right? Every workforce, however, is different. So every optional provision you choose to adopt is going to incur, you're going to incur a cost in some form or fashion. So in this case, you know, you'd have to amend your plan, and there would be likely additional costs related to plan amendments and implementation of the match itself. You know, to Michael's point about enacting new provisions, is your TPA ready and prepared to actually do the mechanism of the match, right? Now, you also have to think about your audience. Think about your plan participants. There's a spectrum along which plan participants would fall relative to this provision, but I think you need to be thinking in terms of one side of the coin or the other, and where do you fall? So as an example, for a tech firm that's competing for young talent, potentially even just right out of school, right? Engineering students, et cetera. These candidates saddled with significant student debt. This could be a really attractive option for a company that looks like that. But on the flip side, consider the 500 employee manufacturing concern. Maybe they're manufacturing widgets, their workforce is more blue collar. Unless there's a very specific reason that the typical member of your workforce would be saddled with a lot of student debt, you know, this is something that they're talking about around the water cooler on a regular basis, and you know that to be true. Adopting this provision could be a colossal waste of your time, right? You could be spending the time that you would be implementing this provision, implementing a provision that would be much more impactful to your workforce than a student loan matching provision. So this all goes to this idea that just because something is possible to implement in your plan, right? 92 provisions. Oh, we're drinking from a fire hose. Not necessarily. Slow down, right? We've got time, and we've got time to consider and think critically about the why of your decision relating to your 401k plan, and then to give you access to professionals who've thought these questions through and thought through some of these concepts on your behalf. So although we haven't stated it, obviously one of the purposes of this webinar is to give you access to professionals so that if you have questions about legal compliance relative to these provisions, you can talk to an ERISA law firm. You need to talk to your advisor. And if you don't have an advisor, get a good one who can help you think critically through these questions.
No, thank you, David. And I would also add, putting my strategic hat on, is as far as whether or not to add a provision like student loan, you want to think about what will your workforce look like, right? As you want to recruit employees. This is a huge differentiator. Again, if you're struggling like many employers to get great talent in the door, if this is something that will help resonate with your audience, potential employees, this is definitely something that you want to consider.
Mm-hmm.
So moving along, because I know we're on a tight timeline today. So we've looked at a couple of optional provisions so far, but there are also quite a few required changes that will impact plan design for employers moving forward. One that could require quite a lift on part of plan sponsors is worth mentioning today. The Section 125 of the Act speaks to the eligibility of long-term part-time employees to participate in a company-sponsored retirement plan. Michael, could you describe the section itself and how it relates back to the stated intent of the Act? And David, can you close with some commentary on challenges to plan sponsors with this particular provision?
Yeah, Carmelo, this may have one of the greatest impacts in terms of overall coverage for American workers as it relates to retirement plans. So effective 2025, this is required. Plan sponsors are going to have to track what's called dual eligibility. It's going to be not an easy, it's going to be an arduous task, but it's going to be up to the employers to track their long-term part-time employees for a 3-year period moving forward. They're going to reduce the amount of time that's required. But again, the intent is to help get more people in the plan so that they'll benefit from a potential company match and put money away for retirement. The challenge we're going to face is most plan sponsors aren't sure or aren't aware of how to do this.
Mm-hmm.
One of the things that makes us different as a consulting firm is we actually track dual eligibility for our clients because a number of them have that in their plan currently. But the impact, David, let's share what your thoughts are on that side.
Sure, and I'm not familiar with every provision of Secure Act 2.0, but of the ones that I am familiar with and could maybe have a decent conversation with someone about, this may be the one that could require the heaviest lift on the part of a plan sponsor. So, for companies without a part-time workforce, obviously this is not a big deal. But so many companies these days rely on part-time workers that I think a lot of companies could be caught off guard by this change if they're not taking a proactive approach. And so again, while this provision doesn't take effect until 2025, and the changes, these mandatory changes to what was initially laid out in Secure 1.0, the original look back period, you could really be caught flat-footed. So again, let me just remind you of the main change. The main change here is to the current requirement under Secure Act 1.0 that part-time employees have 3 years where an employee has completed 500 hours of service, 3 consecutive years. That requirement under Secure Act 2.0 is being changed to 2 years. For those employees part-time who have 1,000 hours of service in a single year, that the provision is not changing. It's identical to Secure Act 1.0. So it's math, right? It's tracking, it's understanding who's part-time, who's full-time, where does that number start? Where does the part-time number stop and where does the full-time number begin? And are you tracking these employees properly? Because we're about to go from a 3-year look-back period to a 2-year look-back period. So keeping detailed and exact records of employee service, that's an impact, right? Including hire dates, separation dates, total hours worked for every part-time employee. Do you have full-time employees who may take on a part-time status at some point, right? There's another variable. So you need to be looking at all the different variables at play in the provision, because again, caught flat-footed, employers could be in a real mess should a participant God forbid, make a complaint to the agency or under audit, an error be identified, because that just opens the door for a further examination of your overall compliance paradigm. So just another great example of where it pays for plan sponsors to be proactive, keep great records, do what we do, what we talk about all the time at HPL, memorialize your process, right? And make sure you understand what you've done and why you've done it and put that in writing.
Right.
Thank you, David. And I know, we've only hit on 3 of the 92. So we have 89
30 webinars to go.
But we have time for just one question before we kind of go into our summary, before we wrap it up. So an attendee has asked the question, does the employee have to be participating in the 401k plan in general for the Roth employer match? So I would say if you're offering a match, right, which requires participation, typically in the plan, the employee puts in so much and the employer matches that, I would say yes. They would be eligible to receive the match. So I guess to expand on this question, if an employer has a non-elective employer contribution, for example, or profit sharing contribution, where, where a contribution's made on their behalf and they don't necessarily have to participate, can the employee elect it? So that's an interesting question. I would think that would apply. The employee would have an option to choose, but there would be a default, right? The default would most likely be pre-tax, unless the employee elects otherwise. I don't know, David or Michael, if you have anything to add on that.
I do have one thought, and I think this could be applied to almost any question asked about Secure Act 2.0. And I'm glad, Lauren, that you asked this question. So I'm just going to repeat the question, which is, does the employee have to be participating in the 401k plan in general for the Roth employer match? The way that the provision is written, and I'm looking at some of the language now, is that Section 604 allows DC plans to provide participants with the option of receiving matching contributions on a Roth basis, effective on the date of the enactment of the Act. So, this is something that's available to you now. We don't have any more guidance, right? I'm not an ERISA attorney, but the ERISA attorneys on my team, they don't know any more about the answer to your question, Lauren, than I do at the moment. We can certainly, based on past experience, based on experience dealing with the IRS in the past, as advisors, based on how matching provisions have worked in the past, we can take a great stab at this question, but I think we just have to go on the face of what the language of the bill says now, which is it's for current plan participants. Barring further guidance, by the way, there will be further guidance because a lot of people are looking for it and the agencies will provide it. But barring some sort of a memo from the DOL or IRS speaking directly to your question, Lauren, we have to go based on what's in the language of the Act itself, which says that that it would need to be an existing participant. So again, please don't take this as legal advice. I'm not an attorney. The bigger point is we have to understand that this Act is in its formative stages, right? Even though it's on the books, we will receive further guidance. So be patient and we can get those answers for you.
Thank you, David. And I know that we're going to maybe in a number of months from now kind of do a follow-up webinar once guidance becomes available for these specific issues. So thank you. So I'm going to begin our summary here. So some basic steps and basic takeaways for the audience. I would say you want to evaluate your employee population, and that includes your what you expect your population to look like, people that you're trying to recruit, retain, identify which elective provisions that would resonate with your employees, to obviously aid in those things with your staffing. So you also want to clearly identify which provisions are mandatory and when, and which are optional. And then I would use this opportunity to evaluate your overall plan design, right? Since some changes will be required, you're going to have to make changes. You're going to be required to do them. So take time to look at current provisions and features to leverage the additional, additional benefits offered through the Secure Act 2.0. And then finally, determine the cost, right? There's going to be, there could be potential cost impact for you as the employer. So, weigh those benefits versus the cost. So, Michael?
Carmel, if you don't mind, I'll jump in.
Yep.
We understand that there's a lot of confusion, right? And we know that this is just these three provisions we discussed today is really just the tip of the iceberg. There's so much more coming down the road. I think we have to be really wary of what's optional versus required, the specific timing of each of these different provisions, how you can use these to recruit, retain, reward. But I think the most important thing is to really seek out professional help. And I use this in an analogy with all of our clients. If you have a heart issue, you don't go see an orthopedist, you go see a cardiologist. So our suggestion would be that you seek someone who has exact expertise and knowledge in all this ERISA space because we think it's that important. And lastly, I think I can speak for David and for ourselves. We're here to help. We do this every day. It's fun and rewarding, and it's enjoyable. And if you have any questions, let us know. We'll be happy to help you get an answer to them.
Good. And I'll just close us out. Thank you, Michael. We did have one other question. Amanda has left. So it's a good opportunity to let you know that if you have questions, please email me at admin@hallbenefitslaw.com, and we'll make sure and gather those questions and hopefully address those in a future webinar. Each of you will be receiving a reminder thanking you for attending, but also reminding you of our next session, which will cover more impacts to small business. That's this Thursday. You'll have a link to sign up for that, as well as the next general session, which will be a week from today at the same time. And then finally, next Thursday, we'll cover impacts to nonprofits. So we will be following up with each of you by email. There will be future webinar links sent your way. We will speak, Amanda, to auto deduction provisions when you also have a waiting period. How will employees elect Roth match, and how is that reported from the plan perspective? We're going to look at these questions that are coming in now, and we're going to try to touch on them in our next session. So all that to say, on behalf of Carmela, Michael, it's been a real pleasure. I hope this has been a bite-sized conversation, and you can go enjoy the rest of your day until we jump in on Thursday. Thanks for being here.
Yes, thank you.
Thank you.